Good morning to the beloved lecturer and fellow classmates. Today, me, Husna, and my teammates are going to present about Law of Tort 2 assignment, which is an IRAP problematic question. We have 5 members in the group, and my name is Husna, and I will be presenting issue and the conclusion of the case. So before I jump into the conclusion, I will summarize the short term of the case. So in this case, Timberland is a company that makes wooden fences, and Anna works in the company. When Anna was working in the company and due to the forklift, the wood fell on Anna, and Anna was hurt, and it also hit on John, and he actually was killed. And Anna is later diagnosed with post-traumatic stress disorder. However, George is walking past the factory, and he actually saw the incident, and he doesn't know anyone there who works there, but he actually got affected too. So he actually had an incident shock and frightened him, but later he develops an anxiety disorder. So in this case, we are going to determine and advise Anna and George as to whether they can sue Timberland for negligence. So for the issue is whether Anna and George are under the duty of care of Timberland to take action against him, since Anna actually was affected by the incident, and George was also affected by the incident. So it is to determine whether Anna can sue Timberland or George can also sue Timberland.
Assalamualaikum and salam sejahtera. My name is AHMAD IMRAN bin FAISAL. So for application relating to the case, we could clearly see that Anna is one of the primary victims because the heavy sheets of wood fell on her, which classifies her to be directly involved in the accident. Although she wasn't physically harmed, she had been put into a fear of injury due to the accident. Anna has also been medically diagnosed with PTSD or post-traumatic stress disorder. So due to the diagnosis, Anna might succeed in her claims against Timberland, should she choose to file a suit against them. So Josh, on the other hand, could be ruled as the secondary victim because he wasn't physically hurt, thus classifies him to be indirectly involved in the accident. Josh didn't know anyone from the factory, thus proving that he doesn't have any emotional relationship with any of the primary victims. He also developed an anxiety disorder, but unlike Anna, there's no proof saying he's medically diagnosed to have a psychiatric disorder. As per laid out in the case of McLaughlin against O'Brien, Lord Wilberforce stated that the possibility of injury by shock alone was insufficient. Hence, there are more things that Josh needs as a secondary victim to succeed in his claims against Timberland. Psychiatric disorders such as anxiety that resulted from seeing an accident firsthand doesn't mean he is permanently mentally traumatized from it. The law grants claims regarding secondary victims and psychiatric disorders, but only to an extent. Hence, one of the things that Josh can start first is by taking a trip to the doctor's office to diagnose him properly and verify that he is currently in the condition that he said he is in via using medical evidences which serve as a proof of his illness. Putting medically recognized mental illness problem out of the picture, we have proven to know that Josh doesn't have any emotional relationship with any of the primary victims, which already makes it harder for him to succeed in his claim since he didn't fulfill all the factors that a secondary victim would have when they are caught in the same situation. Should he try to sue Timberland, the chances for him to succeed will be low, and thus it is not advised for him to do so. So that will be the application from me. The next slide shall be continued by Wani. Thank you.
Assalamualaikum and a very good morning. I bid to my respectful lecturer, Ms. Janatun Nain Umar. I am SYAZWANI Abdullah, and right now I will be continuing my friend's presentation, Ahmad ISYRAF, on the continuation of application towards Anna and George for our assignment. So let's get started. So I will continue with the application for Anna, which, however, it is well established that driving a forklift truck creates a duty of care owed to those who might reasonably foreseeably be harmed by a negligent exercise of that control. Accordingly, it is clear that Timberland as a company owed Anna as a worker a duty of care, which in the application, That fact state that due to Timberland's negligence, some heavy sheets of wood are piled up precariously in their yard. They fall on Anna and John. Timberland's company has breached the duty of care by letting those woods piled up precariously have made such as foreseeable act that could fall onto both, which by mean any heavy works should be taken the precaution and safety before starting. Moving on to the application for George. Timberland did not owe George any common law duty of care on the same basis upon which Timberland owed Anna duty of care, which in the application, the fact that George was shocked and frightened from the incident, but Lord Parker LCJ in Smith and Leach Brain and Co. affirmed that Thin Skull ruled that it has always been the law of this country that a tortfeasor takes his victim as he finds him, which in application of that, it is clear that Timberland does not encompass his anxiety disorder. Secondly, it is plain from the facts that George was not physically injured. Rather, his injury is anxiety disorder and therefore nervous shocks. The relevant authority on this is Page and Smith. Lord Lloyd stated that it is essential to distinguish between primary and secondary victims in cases involving nervous shock. Therefore, it is necessary to establish into which category George would fall. And the authority of Alcock and Chief Constable of South Yorkshire Police considered the distinction between the categories. There is nothing unusual in the recognition by the law that compensable injury may be caused just as much by a direct assault upon the mind or nervous system as by direct physical contact. To conclude this application, it was held persons falling within this description can properly be said to be the primary victim. But in this application for George, it would be hard for him to file a suit against Timberland because George is the secondary victims of the situation. With this, I shall pass to the next presenter to explain more about this case. Thank you.
Hi, madam. So my name is MEGAT and my other group mate is Shanthini. So we'll present rules. And I'll be talking about the first part, which is my part. The first part is negligence. Negligence is a tort which comprises certain elements that need to be proved before liability may be established damages imposed on the tortfeasor. Negligence is established when the three elements are fulfilled. Firstly, there is a duty of care on the part of the defendant. This duty is breached by the defendant and the breach results in some damage to the plaintiff. In the concept of foreseeability of damage, the neighbor principle shall apply. The defendant shall foresee that his conduct will adversely affect the plaintiff. If the answer is no, the plaintiff is not the neighbor of the defendant and no duty of care arises. Conversely, if the answer is yes, this means the plaintiff is a neighbor of the defendant and the latter owes the former a duty of care. Foreseeability includes proximity, whether there is a sufficient relationship of proximity or neighborhood between the alleged tortfeasor and the person who had suffered loss. And then we're talking about the breach of duty. Once a duty is owed, the next step is to determine whether the defendant has breached the said duty of care. A breach would be committed once the defendant does something that falls beneath the minimum standard of care required of him or her and the minimum standard of care in one of the reasonable men. Therefore, the question to us would be whether a reasonable man faced with the same circumstances of the defendant would have acted the same way as the defendant. If the answer is no, then the defendant has breached the duty of care. And then we move it on with the psychiatric illness. Psychiatric illness includes all forms of mental illness, neurosis, and personality change that are medically recognized. Psychiatric illness implies that a claimant can seek damages because they are shocked as a result of the defendant's negligence, upset, or frightened. In order to claim for nervous shock, the claimants have to prove that they have suffered from a genuine illness or injury. In some situations, the illness or injury may be a physical brought as a result of mental shock. If the shock has not caused a physical illness or injury, the claimant must prove that it caused a positive psychiatric illness described in McLaughlin versus O'Brien. Some example of this include clinical depression, personality change, and post-traumatic stress disorder, which mostly occur in reaction to the violent or unexpected death of a close person. However, this does not include people who are simply upset by shock, no matter how bad it is. They have to recognize psychiatric illness, and medical evidence will be needed to prove that. Therefore, claimants who can prove such injury can only claim in negligence if they can be able to establish that they are owed a duty of care by the defendant in regarding the psychiatric illness and the defendant's negligence caused the injury. And then we'll move on to with Shantini.
Okay, I would explain on who can claim for psychiatric illness. So those who are physically injured in the event caused by the defendant and psychiatrically injured as a result of eight other primary victims. Okay, those who are put in danger of physical harm but actually only suffer psychiatric injury is the primary victim. Moving on, those who are not put in danger of physical injury but they only suffer psychiatric illness as a result of witnessing such injury to others falls in the category of secondary victim. Next. Okay, so I'll distinguish between primary victims and secondary victims. So primary victims are those who suffer psychiatric injury after being directly in an accident, and it's either himself physically injured or put in a fear of injury. Okay, there are two requirements for a primary victim. First, there is a possibility of physical injury. And secondly, that psychiatric injury suffered by them is medically recognized, such as PTSD and etc. Okay, for example, in the case of Tiruna Mali against Alagirisamy Pillai against Diners Club, the facts was the plaintiff was a medical doctor and was a member of the Diners Club credit card. Due to a mistake on the part of the defendant, a condolence letter was sent to the plaintiff's wife informing of his death. The plaintiff subsequently sued the defendant for shock, fear, and mental anguish. The court actually denied his claim, even though it acknowledged the plaintiff's discomfort and even anger at the misinformation about his death. This was because that emotion suffered by the plaintiff was just a mere anxiety disorder, which was not recoverable. So that was why the case was dismissed, as the plaintiff's claim was an ordinary emotion of anxiety, which is not recoverable. Okay, moving on to the secondary victim. Secondary victims are those who suffer psychiatric injuries as a result of witnessing or being informed about an accident which involves another. Neither physically injured nor threatened with injury, but can suffer psychological illness and claim for compensation. For example, they are witnessing the death or injury of friends, relatives, or work colleagues. Those whose psychiatric injury has been caused by them bringing about death or injury to others. And lastly, those who have suffered psychiatric injury as a result of acting as rescuers. Okay, the secondary victim must prove that their psychiatric injury was a reasonable and foreseeable consequences of the defendant's negligence. And there are three further tests that have to be taken into account for a secondary victim, which is the first, the nature and the cause of their psychiatric injury. Second, the class of person into which the claimant falls in terms of their relationship to the primary victim. And lastly, the claimant's proximity to the shocking incident in terms of times and place. So these three tests can be witnessed in the case of McLaughlin against O'Brien, 1982, to All England Reports 290A, where it was held by the Lord Wilberforce stated that the possibility of injury by shock alone was insufficient for a secondary victim. The additional following factors must also be considered, which is firstly, the class of person who may sue is important. The person who may claim must have close emotional relationship with the primary victim. The closer the tie between the plaintiff and the victim, the higher the likelihood of the plaintiff receiving the compensation. Secondly is, there must be a physical proximity to the accident in terms of time and space. Physical proximity is extended to include a plaintiff who has not actually seen the accident, but sees the immediate aftermath of it. And the third one is the means by which the shock is caused must be either be as a result of what the plaintiff sees or hears. And lastly is that the defendant's negligent act must result in psychiatric condition that is medically recognized, which was stated earlier, such as PTSD. And that's all from us.
Thank you, madam.
So moving on. So in conclusion, Anna has the right to take action against Timberland. However, George is not able to take action against Timberland because Anna was working at the factory and she was also performing a job at the factory. So Timberland do have the duty of care over the employees such as Anna. So Timberland actually have the right and duty of care to actually take care of Anna. So as she was suffering from post-traumatic stress disorder, and I do have the right to actually sue Timberland since Timberland do have the duty of care to actually take care of Anna. However, as George is not able to take action against Timberland because he is walking past the factory and he doesn't know anyone there, but as the incident he saw and it frightened him, but he was not at the incident, he was not working there. So Timberland has no duty of care to perform over him as he is not an employee and he was just walking past through the factory. So I think that's all for my part and thank you.